Hey everybody, welcome back to the channel today. We're taking a sidestep out of California to talk about a couple of controversial SCOTUS challenges that we're seeing. To do that with us today, we have brought in the volunteer president of CRPA, Chuck Michel. Chuck, how are you today?
Good, thanks, Kevin. Glad to be on your show again.
All right, thanks. But before we get into that, please be sure and like, share, and subscribe to these videos. It really helps us with the algorithms to get this information out to as many people as possible. We want to get this education out to people so that they know when they go to the ballot box in the future, this is what I need to have as a priority. So, Chuck, I wanted to start here with the Vanderstock case. This is a case that was touched on by the Supreme Court. And it has to do with what they call ghost guns. But ultimately here, I was just hoping if you could give us a rundown of where this came from and what the Supreme Court actually did, because they didn't actually come out with an opinion or anything. All that they did was stayed the decision from the Fifth Circuit. So I think a little bit of context here can really help.
The ATF has done a policy change in three areas, at least three main areas. Bump stocks, the slide fire bump stock, frame and receiver, and what is a quote unquote firearm under the law, pistol braces, shoulder braces. So there's three different lawsuits challenging the ATF's authority to make those changes without going through Congress. Essentially, ATF is changing the law, which it had taken a position on for years. It's decided it's just going to take a different position and make all three of those things regulated without going through Congress. And so that's an administrative procedure challenge. That's a challenge to the extent of ATF's authority to promulgate regulations that interpret the law, and in this case, interpret the law differently than they used to. So that's not really, those aren't really Second Amendment challenges. Now, the Vanderstock case was about frames and precursor receivers. When is a piece of metal a firearm? What parts do you have to have with it? This is, they're trying to go after what they've, the latest emotion-laden buzzword is ghost guns. That's what they try and demonize these things by calling them that. But so the Fifth Circuit said the ATF clearly overstepped its authority, that it can't just change this law like this on its own. It has to go through Congress. And they stayed the enforcement of the ATF's new policy so that these precursor receivers and parts would not be illegal based on ATF's new interpretation. What happened at the Supreme Court was the government asked the Supreme Court to stay the Fifth Circuit's ruling and let the law take effect while the case was being litigated through the Court of Appeals and perhaps to the Supreme Court. And interestingly, the Supreme Court granted the government's motion and did not stay the implementation of the injunction, or excuse me, did stay the implementation of the injunction that prohibited the ATF from enforcing this law, that declared this law invalid until the case was resolved. Now, that means that the ATF's new policy is in force and effect right now, because the Fifth Circuit's effort to block it was unblocked by the Supreme Court. So the question is why? Interestingly enough, so in the Supreme Court, you have something called the shadow docket. The main docket is a case gets put up asks the Supreme Court to grant certiorari and review the case, review the lower court decision, and it goes through the open process that everybody's more familiar with. But the shadow docket is these kinds of orders that go on while a case is being litigated, and that's what this was. It was basically a request for an order before the Supreme Court had taken the case, formally taken the case. And what we got was Alito, Thomas, Kavanaugh,
And Gorsuch, I think.
And Gorsuch urged the court to not stay the ruling, to let the injunction take place, to not let the ATF enforce the law yet. And 5 justices ruled to lift the injunction and let the law take effect. Curiously, now we would expect 3 of them, but curiously, Barrett and Roberts did not vote to block the law from taking effect. They voted to allow it to take effect. And so the question is, where's Robert and Barrett coming from? Now, Roberts is kind of wishy-washy. This is a sort of a bit of a political case because it's ghost guns. And apparently there are some bad guys getting a hold of these unserialized firearms that you don't have to go through an FFL to get. And the government is making a lot out of that. But Roberts has kind of been wishy-washy on this all along. But we thought Barrett was a Second Amendment hardliner, and she voted to let the law take effect too. Now, remember, I said at the beginning, it's an administrative procedures, executive authority challenge, not a Second Amendment authority. So there are a lot of things going on with the scope of administrative authority. That's called the Chevron doctrine. A lot of times there's been Chevron deference given to government agencies to say what they think a certain law means and then pass regulations consistent with what they say it means. But they shouldn't really, there's a lot of controversy about whether or not government agencies are really entitled to that kind of deference because they're so politicized. I've gone up against this a number of times, and the government always interprets a statute in a way that gives it more power. That's the bottom line. The government never really tries to be fair about things or understand individualized circumstances. They just want to interpret a law in a way that gives it the most power. And so there's a big effort to rein that back. But that doesn't explain why Barrett would let the law take effect. So there may be she has expressed some concerns with the shadow docket. She's expressed some concerns with some other procedural aspects of these kind of administrative stays or blocking these administrative stays. So it may be as simple as that. It may not be that she really believes that the ATF had the authority. It may be that she just didn't want to get involved. But then the question is, well, then why not just let the law be blocked, maintain the status quo until the case is resolved rather than the law going into effect? So she's kind of a big wild card right now. There's a lot of chatter on the legal boards about why she didn't join the other 4 justices and vote to block this law while it was litigated.
I mean, how commonplace is that? We've seen stays be implemented while cases continue to be litigated all the time. Is what she did. So I understand there is a question: why is she on the side that she's on when it comes to this? But administratively, is this something that is out of the ordinary, or is this something that happens all the time?
No, this happens all the time. They don't always, it's not they always grant or they always deny. They may grant or deny a request for some kind of an order before the case gets to the Supreme Court. And so it is procedural. It is primarily procedural. And so it may not mean anything. It may just mean that she wasn't comfortable getting involved right now. But then, I don't know, she got involved. They let the law take effect. So, but generally, these kinds of shadow docket requests and orders that come out of those requests are just procedural, and they're not particularly controversial. In this case, though, you had 4 dissents. A lot of times it's unanimous because it's procedural, not substantive. They're not getting into the merits of the argument per se.
Well, yeah, and I think that's an important distinction here, as you have, the media is going to spin things a certain way so that they can get as many clicks as they can get. So, all of those rumors going on that the Supreme Court made a decision, they haven't weighed these arguments yet. They simply stayed an injunction. And I'm assuming, Chuck, that they're going to review this next session, right? Because this session is coming to a close.
They did. And that's another factor that may be going into this, because the Supreme Court in the Antonic case, when the Second Circuit wouldn't block a law from taking effect, there was a couple of dissents that said, you better get this done fast or we're going to get involved again. That was the last time we saw one of these requests going up to the Supreme Court on the shadow docket to enjoin the enforcement of the law, which was the Antonic case. So The Fifth Circuit has scheduled oral argument for September 7th, which is very, very fast by court standards, time standards. So it's going to be resolved, I think, pretty quickly. We'll get an opinion out of that. And then depending on whether we win or the government wins, one side or the other will ask the Supreme Court to take the case, I'm sure.
Well, yeah, this is definitely something that we should be keeping an eye on, as we've seen plenty of regulations and legislation in California specifically on these precursor parts, trying to call something that it's not, and basically enabling the government to categorize people as criminals overnight. Chuck, another one that I wanted to talk to you about that involves an actual criminal, a pretty controversial case. Here we've got the U.S. versus Rahimi. So if you could take us through the Fifth Circuit, this is another one coming out of the Fifth Circuit. Could you take us through the Fifth Circuit case and also kind of describe what the Supreme Court's interests could be in this case? There's obviously a lot of bad mouthing going on because of the person who was originally on trial here. Could you sort of explain this one to us and how it's prevalent in the Second Amendment community as a whole?
So the question in Rahimi is, can an entire class of people, without considering their individualized circumstances, be banned from possessing firearms based on the class that they're in? Now, there are several classes of folks that are banned from possessing firearms under the law. One is felons. That's probably the one everybody's familiar with. There are certain misdemeanor convictions that prohibit you from possessing firearms, especially in California. And you may never even know it, because it's the law on what convictions prohibit you from possessing firearms in California is very confusing. If you've got a TRO or a restraining order out against you, you can't possess firearms. If you're on probation, well, that's not a good example, because probation would be an individualized circumstance. Your case was considered specifically. But when you're banning these classes, this started back when we didn't want Indians, Native Americans, or freed slaves to have firearms. And so they banned all Indians from possessing firearms and all freed slaves from possessing firearms. And the states have been trying, believe it or not, to rely on those kind of racist laws to justify being able to ban an entire class of people from possessing a gun. Cannabis users is the other big one. And cannabis has been challenged a couple times, and a case just came out of the Fifth Circuit yesterday that said you can't ban all cannabis users from possessing firearms, particularly if they're sober. You can't just ban cannabis users as a class of people who can't own guns. But in that case, that's the Daniels case, the court said, there's a lot of inconsistent application of the Brewing decision going on, and Supreme Court, we really need help. Well, so in all of those contexts, cannabis, felons, misdemeanors, restraining orders, Rahimi is one of those. He was in possession of a firearm when he had a restraining order out against him. He was criminally prosecuted, and the Fifth Circuit said that law is unconstitutional. The government asked the Supreme Court to review that case, and it granted cert. So the Rahimi case is a concern in one respect, because Mr. Rahimi is not the poster child for Second Amendment rights. He's not a good guy. And he probably shouldn't have a gun. But the question is, should he be prohibited based on a class, or do you got to look at him individually and say, you're a bad guy, you can't have a gun? So the Supreme Court's going to have to deal with that. And in the process, they're going to have to deal with some methodology in answering, in helping lower courts determine what the test is to determine whether or not a prohibited person category law, at least, is constitutional or not under the Second Amendment. Remember, in Bruin, the issue was whether or not a state could require folks to demonstrate a special need beyond just self-defense or defense of others to carry a firearm, to get a license to carry a firearm in public. And the court said, you can't. But that wasn't really the most significant thing about Bruin. The most significant thing about Bruin was that it established a new methodology. And that methodology was, step one, you look at the language of the Second Amendment and decide whether it covers the conduct that's being questioned. So if you're bearing a musket or you're bearing a hunting rifle, or you're bearing an AR-15, or you're bearing an M16 fully automatic, are those arms under the right to keep and bear arms? And the states have been arguing that magazines aren't arms, that fully automatic aren't arms, that AR-15s are not arms that are protected under the Second Amendment. In other words, they're twisting the Bruen decision to try and make it a two-step test again, which it's not supposed to be. It's supposed to be a simple question. Are there bearable arms involved? And if there are, then the Second Amendment applies. Then the burden of proof shifts to the government to show that the law is constitutional. And to do that, they have to point to some historical law, an analog law, that would demonstrate that the founding fathers would have tolerated a modern law because they tolerated something very similar to it back in 1791. So this is where the courts are also getting wrapped around the axle, because they are accepting more or less. Some courts are accepting weaker analogs, some require more specific analogs. And so we're getting a lot of different types of different rulings on the same challenges. There's some jurisdictions right now where you're a criminal in one circuit and you're not a criminal in another for doing the same thing. So we think in Rahimi, the court is going to have to address that methodology, clarify some of the confusion, and I would say deliberate confusion that's been sowed by the Bloomberg group, who helps these states write their briefs, to try and bollocks up the Bruen analysis so that more gun laws can be found to be constitutional. So we got to watch Rahimi carefully. CRPA will be submitting an amicus brief in Rahimi. The Second Amendment Law Center is already coordinating an amicus campaign with a number of CRPA strategic partners and with the federal public defender who is defending Mr. Rahimi. So we're really working very hard to make sure that the court does not go overboard and sort of water down the Bruen test so that more laws that should not be held as constitutional or are still struck down as unconstitutional.
Well, that was kind of my final question or point for you. Is this something that the Supreme Court actually takes to solidify and further dive into their explanation on how Bruen should work? You sort of answered that, and yes, absolutely, this is something to be watching. So as time goes on, are these things, in your opinion, going to be handled in the next session of the Supreme Court? Like, what is the time frame that we see?
Briefs are going to be due in October or November. Argument will be sometime probably after the first of the year, and we'll get a decision in Rahimi next June.
Awesome. Well, definitely something to be looking forward to. Chuck, I really appreciate you coming on and giving us some of these explanations. It's definitely something to watch for. Thank you very much for being with us today.
Happy to come back anytime.
And just in case you came in halfway through the video, please be sure to like, share, and subscribe to this channel and to these videos. It really helps us get the word out. We're trying to educate as much as we possibly can. Thanks, guys, and we'll see you on the next one.